He built his empire on contracts, until one tenant destroyed everything. On a Tuesday morning in early November, a man walked into a courtroom on crutches. By Thursday afternoon, he wished he hadn't. The contractor had spent 23 years building a reputation in his trade. Residential renovations, bathroom remodels, the occasional kitchen gut job. He was the kind of businessman who ran a tight ship and prided himself on it. When he purchased a small duplex on the east side of town as a rental investment, he approached it the same way he approached every project, methodically and with an eye toward protecting his bottom line. The tenant, a woman in her mid-40s who worked as a school librarian, had rented the upper unit for 3 years without incident. She paid on time. She caused no trouble. By all accounts, it was a quiet, unremarkable landlord-tenant relationship. Until the February morning, it wasn't. According to the contractor, he arrived at the property at approximately 7:40 a.m. to perform a routine inspection of the exterior staircase, which he claimed had been flagged for maintenance. He said he climbed the wooden steps leading to the tenant's unit, and on the third step from the top, his foot went through a rotted plank. He fell hard, twisting his left ankle and fracturing 2 bones in the process. He required surgery. He missed 11 weeks of work, and he blamed her. His attorney laid the case out cleanly. The contractor was seeking $94,500, covering medical bills, lost wages, and general damages. The argument was straightforward. The tenant had been made aware of deteriorating conditions on that staircase, had failed to report the specific board in question despite witnessing its degradation, and had therefore contributed to the conditions that caused his injury. Under the lease agreement, tenants were obligated to notify the landlord of any hazardous conditions. She had not. He had photographs, he had a medical file 2 inches thick. He had a contractor's lien on future earnings as evidence of real financial harm. The tenant's attorney offered a different picture. She had never, in 3 years, received any written notice requesting access for an inspection on that date. No text message, no email, no voicemail. The contractor had not scheduled the visit. He had simply shown up. More importantly, the staircase was the landlord's responsibility to maintain. She wasn't a carpenter. She wasn't trained to identify structural rot beneath a painted surface. She used those stairs every single day and had felt nothing alarming underfoot. Her attorney argued that the contractor, a man who built and repaired structures for a living, had failed in his most basic duty, maintaining the property he owned. The courtroom shifted on the second day of testimony. A property inspector took the stand. He had been hired by the tenant's legal team to examine the staircase after the incident. His report, entered into evidence as Exhibit 14, contained a finding that stopped the room cold. The rotted board, he testified, showed decay consistent with 18 to 24 months of water intrusion. This was not a condition that had developed recently. It had been present, visibly deteriorating, long before the date of the accident. But that wasn't the twist. The twist was what he found beneath the step. Someone had painted over it. Fresh paint, applied over old rot, covering the discoloration and soft wood that would have made the damage visible. The inspector's report noted brushstrokes inconsistent with the rest of the staircase's weathered finish. When cross-examined, the contractor could not explain why that single board bore paint that was, by chemical analysis, less than 6 weeks old. He had painted over a hazard he already knew existed. Then he had walked onto that staircase and fallen through it anyway. The judge did not mince words in her ruling. She found that the contractor, as property owner, bore full and primary responsibility for the dangerous condition of the staircase, a condition he had at minimum been aware of and deliberately obscured. The tenant had no duty to report a defect she had no reasonable means of detecting. The claim of $94,500 was denied in its entirety. Furthermore, the judge referred the matter to the city's housing authority for investigation into code violations at the property. The contractor left the courthouse without his crutches and without his case, but with considerably more scrutiny than he'd arrived with. The tenant returned to her job the following Monday. She did not renew her lease when it expired that spring. There is a version of this story where the contractor's injury was real, his pain was real, and he genuinely believed someone else was to blame. People have a remarkable capacity to edit their own memories, to forget the can of paint in the garage, to forget the choice they made on a cold morning to buy a little time on a repair they kept postponing. The question this case leaves behind is not whether he lied. The question is whether he ever knew the difference.